Hi, this is Suman Dash Bhattamishra, Assistant Professor of Law at National Law University, Odisha, Cuttack. And today I am going to discuss the law relating to attempt with you. The current module discusses section 511 of the Indian Penal Code, which makes a reference to the law of attempt. However, the term attempt has not been defined in the IPC. So, the current module has been designed with the purpose of rendering three primary objectives. First and foremost, I am going to introduce students to the concept of attempt. Secondly, we are going to discuss the various elements of attempt, their complexities and facets in criminal law. Finally, the objective is also to provide an insight into the significant case studies in the area of attempt. Now, before we move into the domain of attempt, I think it will be relevant for us to discuss the various stages in the commission of a crime. Now, as we know, every crime is said to be committed after passing through four successive stages. Number 1, intention; number 2, preparation; thirdly, attempt; and number 4, commission. The first stage is where an individual forms an intention before indulging in the actus reus, which finally leads to the commission of a crime. Intention per se is not punishable under the Indian Penal Code. The second stage is one where the individual initiates the commission of an offence by arranging means, methods and methodologies necessary for the commission of a crime. Now, this is where we say that the stage of preparation has come into operation. Following the stage of preparation and a bit ahead of this stage is the stage of attempt. Now, attempt is something which is ahead of preparation and at the same time is also the place wherein the punishment or liability is fixed for an individual. Now, to illustrate the difference between preparation and attempt, I would like to cite an illustration or example. So, for instance, when the offence of robbery is planned to be committed and the person concerned purchases sacks or let us say a rifle or a pistol or a gun for the purchasing of for the commission of the offence of robbery, this is exactly where we say that the stage of preparation has begun. Now, the stage of preparation, as I mentioned earlier, is a stage where means, methods, etc. are procured for the commission of a crime. Now, after the stage of preparation, we have the stage of attempt. So, for instance, lifting a gun and trying to shoot a person would qualify as the stage of attempt. While the first two steps, that is intention and preparation, are not penalized in criminal law, the third stage, that is attempt, is where the crime is said to have been committed partially or is intended to have been committed, and this is where we start fixing liability for the commission of an offence. Now, as a general rule, preparation is not punishable. However, under certain circumstances and under certain grave offences, we also provide punishment for preparing to commit the crime. This is true in the context of certain serious crimes like robbery, etc. Now, let us take a look at attempt as an inchoate offence. Now, students, when I began with the module, I initially stated that attempt is an inchoate offence. What exactly is meant by an inchoate offence is something we should know before we proceed into the details of attempt. Now, attempt has certain other offences which are read together with it, and they also form the category of inchoate offences. So, for instance, incitement, conspiracy, they also qualify as inchoate offences. So, like incitement and conspiracy, attempt is an inchoate offence in criminal law, and the term inchoate means undeveloped, just begun, incipient, in an initial or an early stage. inchoate offences cannot be understood in isolation and they must be read in conjunction with the complete substantive offences. So, for instance, when we say conspiracy or attempt or we refer to incitement, these offences can never be understood on their own, because for instance, when we say incitement, per se understanding incitement is extremely difficult. So, we generally read incitement along with another substantive offence. So, for instance, we may say incitement to commit the offence of murder. So, also attempt to commit the offence of murder. So, as we can see here, murder is this complete substantive offence, whereas attempt or incitement are the inchoate offences which must be read in relation to and in conjunction with the substantive offence. A characteristic feature of inchoate offences is that they are committed even if the substantive offence does not reach a stage of completion and no consequence ensues. So, for instance, if the offence of murder has not been completed, even then a person can be guilty of an attempt to commit murder. So, the actus reus required for the commission of murder may not have been complete, but the mens rea of murder is complete in an attempt, and therefore, the attempt itself would be said to have been committed at this stage. However, some scholars disagree with the usage of the term inchoate, because according to them, offences like conspiracy, attempt, incitement are complete in themselves, which means when you talk about the actus reus of conspiracy or actus reus of incitement, or even for that matter the actus reus of attempt, the actus reus according to them is complete. So, the incomplete actus reus for attempt is actually, according to these scholars, the complete actus reus for the offence of attempt. Therefore, according to them, the usage of the term inchoate is not relevant and should be done away with. So, in different stages in the process of reaching the end, that is the actual commission, the offence which they are referring to at this stage is something that may have been committed as maybe an anticipatory crime. So, the alternative terminology that we often use for crimes like attempt, incitement or conspiracy, that is the so called inchoate crimes, is also sometimes anticipatory crimes or preliminary crimes. The problem associated with penalizing inchoate offences is that liability is attached to the act which is very remotely connected with the exact harmful consequence contemplated under a specific substantive offence. Now, this point needs to be elaborated a bit further. A very important problem attached with the offences which are inchoate in nature is that we generally do not know how to fix liability. It is very difficult to fix liability because the act is very remotely connected with the actus reus which is required for the commission of an offence. To illustrate this point, let me take the example of a case of murder. So, for instance, when somebody pulls the trigger and the gunshot hasn't been taken towards the other end, that is the gunshot hasn't been released from the gun, even at that stage we hold the person responsible or liable for attempting to commit murder. However, the pulling of the trigger is actually very remotely connected with the offence, that is murder. So, when we fix liability in inchoate offences, we need to be very careful because this is also a stage where we are concerning ourselves with extremely remote actions or remote activities which may or may not be penalized in the IPC. So, fixing liability is a matter of very major concern for us. While that is true, it is also correct to say that inchoate offences may have harmful consequences on certain occasions, and in many other situations no harm may be resulting from inchoate offences. No matter what, they can still be punishable because the idea of incomplete offence suggests that the mens rea required for the commission of offence is complete. The actus reus for inchoate offences covers a very wide range of behavior, and therefore, it has to be placed on the mens rea to determine the liability or the exact punishment which is to be provided in such cases. So, we need to emphasize the mens rea in cases of inchoate offences. So, for instance, in cases of attempt, incitement or conspiracy, we need to figure out that the mens rea is 100% present for the commission of the offence. Now, let us take a look at an attempt, at defining attempt. So, many scholars have actually made a lot of effort to bring out various elements of attempt in their definitions. However, the IPC does not provide a definition of attempt in the Indian Penal Code. So, in this slide, it will just be pertinent for us to take a look at various scholars and their definitions of attempt. So, for Stephen, there are few steps which need to be present and few elements which need to be present for attempt to have been there. The first important element is the doing of an act in furtherance of an intention to commit a specific crime. Secondly, such acts should form part of a series of acts which taken together and if uninterrupted, and this is the point which needs to be emphasized, if uninterrupted would lead to the actual commission of the crime. Impossibility of actual commission of a crime does not have an impact, according to Stephen, on acts which qualify as attempts if the aforementioned conditions are satisfied. Finally, an attempt can be made even if the offender voluntarily desists from committing a crime. Likewise, a leading scholar, Halsbury, has also stated that attempt has three primary elements. First and foremost, there has to be an overt act which is immediately concerned with the commission of a crime or an offence. Such act should be done in furtherance of a guilty mind, and the overt act should form part of a series of acts which, in the absence of interruption or frustration, would end in the commission of the actual offence. Andrew Ashworth likewise highlights two important elements in attempt: the fault element, firstly, which refers to the guilty mind or intention of the offender; secondly, the element of conduct, which refers to the minimum conduct necessary to qualify as attempt. So, when we take a look at each of the definitions provided by Halsbury, Andrew Ashworth, and even by Stephen, few things come out very clearly. First and foremost, when we discuss attempt, the most important thing which is to be present and which actually links it up with the commission stage or the final stage of an offence is the presence of an intention. But the mere presence of an intention does not make attempt punishable. So, along with the presence of an intention, there has to be an act which is in furtherance of the intention and progresses towards the stage of commission of the offence. Now, this is where attempt is said to have been committed, or the inchoate offence of attempt is said to have been present. Now, having understood the various elements of attempt as highlighted by leading scholars of criminal law, at this stage we should also try to answer a very important question in criminal law, which is at what time or what point of time does attempt begin and where does attempt culminate. So, this is something which has perplexed scholars of criminal law for a very long time now. So, at what point of time does the offender do something which we can actually label as more than preparatory, or the link between preparation and attempt has always been confusing, because it is very difficult to make out at what point of time preparation ceased to exist and at what point of time it qualified as attempt. Further, there may be situations where attempt and preparation may actually blend into each other, making it very difficult for us to isolate one from the other, and it is then that the issue becomes even more complicated. So, whether an act has reached the stage of attempt or was merely preparatory, it becomes the matter or the subject matter of a very bigger debate in cases where an attempt has been interrupted at some level. So, imagine a scenario where somebody pulls the trigger, gets the gun and pulls the trigger and tries to shoot at a person. Now, if you look at the three successive stages of actus reus here, where exactly would you say that the person ceased to prepare for the commission of the offence and actually went a step ahead and entered the stage of attempt. So, this matter becomes particularly difficult, as I said earlier, in cases where attempt and preparation seem to have blended into each other or seem to have faded into each other. In these circumstances, the litmus test of determining what attempt is or at what stage attempt began is a very difficult problem for us to solve. So, most scholars opine that the litmus test for identifying attempt or the ultimate test for identifying attempt is to figure out whether a particular act was merely preparatory or a step ahead of the stage of preparation. And the other important thing that we need to ask ourselves is whether the accused engaged in the commission of the crime. So, whether the accused was standing at the threshold of the commission of the crime is a very important question, which probably can lead us to the solution as to whether there was a situation of attempt or it was absent all the while. So, scholars have identified three primary tests for distinguishing attempt from the stage of preparation. The first test is the test of proximity, which has been applied in many cases earlier by various courts across India as well as England. Then we have the test of locus ponipotentia and finally the test of equivocality. The test of proximity is the first and foremost test and has been used in a majority of cases. It has come to the surface with one primary question: was it the last act that was legally necessary for the offender to do? It is not required that it was the last act which the offender legally intended to do, but what is necessary for us to figure out is whether the act indulged in by the actor, in this case the offender, was the act which was legally necessary for him to do. R versus Taylor is a very significant case in this relation in the test of proximity. Here liability was fixed for lighting matchstick to set fire to a stack of hay, although the offender in this case extinguished the matchstick due to fear of being perceived by someone. In this case, the court had fixed liability on the offender on the ground that the act of lighting the matchstick was proximate enough to the commission of the offence with which he was charged. Along with the test of proximity, we often follow an ancillary test which is called the Rubicon test. Rubicon test had come to surface in the case of Widdowson and in the case of Stonehouse as well. Here the immediate connection with the commission of the offence is what we need to figure out for ascertaining whether a case is one of attempt or not. So, what we do in this situation is we try to figure out whether the last act or the act of the participant or the offender in this case was something which was connected very proximately with the commission of the offence, and if the answer is affirmative, the Rubicon test is said to have been satisfied and the person is held responsible for attempting to have committed an offence. Now, Guffler followed by John's case again have reiterated the principle or the test of proximity, where the accused was indicted for attempted murder, although he claimed that there were at least 3 other acts which need to be accomplished before the offence was actually committed. Now, in the case of Jones, an interesting matrix of facts had surfaced. In this case, the person concerned, the offender, had entered into the car and pointed a gun at the person's head, and in this case he was charged with and also held guilty of attempted murder. Now, the plea which the offender had come up with was this cannot be a situation of attempt, because there were at least a minimum of 3 other stages which had to be passed for the commission of the offence or the actual shooting of the person concerned. So, he pointed out that the pulling of the trigger was a necessary part of it, along with which he said that the target had to be fixed and the actual shooting had to take place. So, in this setup, it was not pertinent for the concerned person to highlight that the opposite side to highlight that by just entering into the car and pointing a gun, he could be held responsible for the commission of attempted murder, because the act was not proximate enough. However, the court had held him guilty in spite of the fact that or the plea that 3 other stages had to be reached, with which the court did not agree. In the case of state of Maharashtra versus Mohammad Yaqub, which is a very famous case in the Indian scenario, wherein the law relating to attempt was discussed, Justice Chinnappa Reddy and Justice Sarkaria had 2 distinct opinions to be presented. So, Justice Reddy pointed out that measure of proximity should not be in relation to time and action, but it should be in relation to intention of the concerned person. Likewise, Justice Sarkaria pointed out a very different opinion in the same context, wherein he laid down that the actual physical proximity of the act is the testing stone for finding out whether attempt was existing in a given scenario or not. The second test is otherwise called the test of locus plenipotentiae. The test that we take up in this particular context is in finding out whether at the stage of preparation the person could have made taken a step back. So, which means that if the accused, in this case it can be shown in a matrix of facts that he had the right to, or he had the opportunity to take the step back or not really lead the attempt to a particular result or accomplish the attempt, this is exactly where locus plenipotentiae is said to have come into operation. So, the test of locus plenipotentiae suggests that the test requires us to be present in a given scenario, wherein the ultimate test is to find out whether or not the person could have taken a step further, taken a step back. So, which means attempt is said to have been committed if the act was such that there could not have been a moving behind or a moving back from the concerned act. Now, the test of equivocality is the third important test which needs to gather our attention. So, if the act unequivocally indicates that the offender intended to commit the offence, this is precisely where the test of equivocality is satisfied. So, another important issue which arises in the context of impossibility and attempt is the case of the question of whether an impossible act could also qualify as an attempt. So, if an attempt is made to do something which was actually impossible to accomplish, then would it at the same time call for liability, or could the person be exonerated from the commission of that offence? So, the case of Queen versus Collins is something that needs to take our attention here. Here the pickpocket had put hands in a person's pocket for stealing money from his pocket, but the pocket was found to be empty. In the case of Queen versus Collins, no liability was fixed on the person. However, a subsequent case called the case of R versus Ring was another important scenario, wherein in the same matrix of facts, a person, or in this case a woman, was held liable for the offence of pickpocketing or theft in this matter. So, in this situation, the woman had put her hands into someone's pocket, which was ultimately found to be empty, and according to Queen versus Collins case, as per the law laid down there, she should not have been made liable for or guilty for the offence of theft. However, the court held her responsible for the commission of theft. So, R versus Ring actually suggests a very different stand that was taken as in the case of against the case of Queen versus colons. So, illustrations A and B of section 511 actually reiterate the point that was laid down in our versus ring. Now, attempt to commit murder is something that needs to be distinguished here from regular forms of attempt. Now, the case of R versus Nidha is something that needs to be taken care of. So, a special provision has been made under section 307 of the Indian Penal Code, where attempted murders are penalized. So, the question in this case was whether a person should be held liable for the commission of the offence under section 511, or whether for attempting to commit murder liability should be incurred as per section 307 of the Indian Penal Code. So, here the court had opined that application of section 511 is a general principle and would not apply in cases where the specific provision has been made in relation to that offence or in relation to the inchoate offence of attempt. Since attempt to commit murder has already been covered under section 307 of the Indian Penal Code, therefore, it is not necessary to rope in provisions of 511 under this scenario, in this scenario. So, as to conclude, it is necessary for us to figure out certain important things that have come into operation. So, the first important thing here is that the 5th Law Commission report has made a very important recommendation in this relation. Now, as I told you in the earlier slides and in the earlier discussion that we had in the earlier part of the lecture, I mentioned that attempt has not been defined in the Indian Penal Code. It has been touched upon under section 511, the last section of the IPC, and of course, it is in this light that the 5th Law Commission report is very strong about the point that we should have emphasized on the law of attempt a bit more, and it is dissatisfied with the way in which attempt has been put in the IPC. Suddenly in 511 it starts showing up, whereas no mention has been made of it anywhere earlier. So, the 5th Law Commission has suggested an introduction by way of amendment of section 120C into the IPC, wherein a specific definition of attempt is provided. So, as we can see, attempt is an inchoate offence which is being dealt with by section 511 in a manner which needs more in-depth analysis, and at this juncture attempt has had to go through various phases of refinement. A lot of discussion has taken place about what amounts to preparation and at what stage it can qualify as attempt. So, at this stage it will be pertinent for us to sum up the discussion that we had throughout the lecture. So, the first important thing that we need to notice about attempt is that it is an inchoate offence or an incomplete offence, and it figures as this third stage in the commission of a crime. It is right after preparation and precedes the stage of commission in a crime. The most vital elements of attempt are intention to commit a crime, doing an act in furtherance of that intention which is more than preparatory, and failing to accomplish the crime. The Indian Penal Code has not defined attempt, but it has made a general punitive provision under section 511. Section 511 is applicable only where a special provision has not been made in the Indian Penal Code for attempt to commit an offence. It is necessary for us to distinguish attempt from preparation, and the following tests have largely been followed: the test of proximity, the test of locus ponipotentia, and the test of equivocality. Liability can be fixed for attempting to commit an act which is otherwise impossible. This also we have discussed in depth, and it is a very important point because it has gone through a lot of judicial analysis as to whether such situations can actually amount to a situation of attempt or not. So, we need to remember that attempt in its own way has to be understood in conjunction with the mens rea which is present. Since emphasis in fixing liability in the case of attempt is on the availability of mens rea and the actual quotient of mens rea existing, it is important for us to figure out whether the person had the mens rea or not, whether it resulted in the commission of a possible or an impossible act is not the crux of the matter. And in this situation, we would say that even if the act which one was associated with turned out to be impossible, if the intention to commit the offence was present, it would still qualify as an attempt. That is all. Thank you.